A negative effect to the title of your property. That's what the City of Richmond is warning a recent court decision could have on some of its residents.
One thing is clear is that this will significantly affect the titles that are directly involved.
In a letter handed out to about 150 residents along the Fraser River, Richmond Mayor Malcolm Brodie said the status and validity of their ownership could be compromised by an August decision handed down by the BC Supreme Court that granted Cowichan Tribes Aboriginal title to the area.
Given the fact that 120% or so of the land that's in the province is subject to Aboriginal claims, yes, I think it's going to go on and on and on. And if not overturned, the significance is going to be felt for generations to come, if not forever.
The 863-page ruling marked the end of the longest case in Canada's history, but it promises to continue, with appeals launched by the province, the City of Richmond, and Musqueam Nation soon after it was made. That means legal clarification over the ownership isn't likely anytime soon. And Richmond City Councillor Alexa Liu says that ambiguity is already creating real impacts on those within the claim area.
The banks are realizing that it's a big deal and they're already acting on it. So banks have pulled mortgages on projects that people have been trying to start. We heard from another woman, she had moved in with her mother because her mother was getting old. The mother passed away and now she's trying to sell the property. She's dropped the property by over $40,000, can't sell it because nobody can get a mortgage on the property. And now the realtors are realizing that they can't actually sell the property because there's open litigation on it.
At an unrelated press conference, Premier David Eby stressed the urgency for a resolution.
It's a big deal, and it's crucial for our economy, for just the basic economics of a family, that people understand their private property rights. It's the basis of how things work in the province. So clarity and resolution is urgently needed.
But critics say the way the city is framing things amounts to fear-mongering, arguing that this is simply an extension of existing case law, and the ownership ambiguity is only being made worse by choosing to appeal the decision rather than enter into a negotiation like the court ruled.
The courts will eventually, whether or not it's the BC Court of Appeal or the Supreme Court of Canada, they're going to send the parties back to negotiate the agreement. So, I mean, I think they have a choice of do it now or live like with the legal uncertainty for for a decade, possibly.
The 7.5-kilometer parcel of land at question represents the first time Aboriginal title has been granted to an urban area in BC. But Merle Alexander, a legal expert, says there's already a framework for how Aboriginal title and fee simple ownership can coexist.
There's a pretty clear template, like in the Haida title affirmation agreement. Like there is two specific clauses that very clearly say that the Haida Nation acknowledges the coexistence and the continuing fee simple interests within the title area.
Richmond will hold an information session next week, aiming to clarify something that may remain unclear for years to come. In Richmond, Jack Rabb, City News.